Before we get into the inner workings of the CP team, we wanted to discuss one of the key consumer protection requirements in Illinois Shines. This is the disclosure form. Since the inception of the Illinois Shines program, the Illinois Power Agency has required that approved vendors and designees provide customers with a standard disclosure form. As I mentioned, the disclosure form is a key consumer protection requirement in Illinois Shines, as it ensures customers receive accurate information about the program, the solar project, including its size, cost, operations, warranties, and financial benefits, and consumer rights. It also allows customers to shop around and compare offers from multiple installer or AVs before signing. The approved vendor or designee must provide a copy of the applicable standard disclosure form with all relevant fields completed to the customer, including the relevant informational brochure attached as the first 2 pages. The approved vendor or designee must provide the completed standard disclosure form, and the customer must sign that disclosure form before the customer signs either a contract for installation of a DG or distributed generation system or a subscription agreement for community solar. It is a program violation for a customer to sign a disclosure form after signing a contract or subscription agreement. The point is that the consumer has all the information included in the disclosure form presented, and that they sign that disclosure form prior to then signing an installation contract or subscription agreement. Once the customer signs the disclosure form, any changes to the customer's proposed system, pricing, payment structure, or other changes to the information on the disclosure form will require the installer or approved vendor to generate and get the customer to sign a new disclosure form. There are a few limited exceptions to this requirement, and those are laid out in a document linked here on the second to last bullet. Some exceptions that are stated in that document include minor non-material typos that don't cause confusion, certain minor changes to the collateral fee or rec incentive amount. Those exceptions, again, are explained in detail on that document. Lastly, we have a wealth of educational resources on the website regarding disclosure forms. The last bullet links one set of those resources. The link takes you to the disclosure form deep dives, primarily aimed at consumers, that explain the purpose of many fields in the disclosure form. In the program resources and ongoing opportunities presentation, we go into more depth on these deep dive resources. We encourage you to review those resources before reaching out to the program administrator with any questions. Next slide, please. The Consumer Protection Team investigates consumer complaints and other potential program violations and enforces requirements laid out in the Consumer Protection Handbook and Program Guidebook, both of which are linked here. When the Consumer Protection Team receives a consumer complaint, we will reach out to the relevant approved vendor or designee to attempt to facilitate a resolution. When we reach out, we will do so by email, and will include the information here in the second bullet. A summary of the alleged issue, a deadline to acknowledge receipt of the communication, and a deadline to respond. The Consumer Protection Team will take the approved vendor's responses, actions taken to resolve customer complaints and potential violations, and their responsiveness into consideration when determining whether to move forward with corrective action, a compliance plan, a warning letter, or a suspension. Next slide, please. The program believes in the importance of transparency on consumer protection issues, so consumers have all relevant information when making a decision on companies for their project's installation or subscription agreement. Accordingly, we maintain a consumer complaint report detailing all consumer complaints received by the program administrator, the date of the complaint, the company who is subject to the complaint, a brief description of the complaint, and whether the complaint was resolved, closed without resolution, closed because the customer became non-responsive, or is still under investigation. When we engage with an entity about a consumer complaint, we will primarily do so via email, and will ensure to set deadlines for the entity to respond so we can ensure the complaint resolution process proceeds expeditiously. The chart on this slide shows the types of complaint categories and volume received in the calendar year of 2022. As you can see, the top categories of consumer complaints in 2022 were related to delays in approved vendors and designees submitting the Illinois Shines application for customer projects, mechanical and installation issues, such as leaky roofs, and misleading marketing. Next slide, please. If the program administrator believes that an entity has violated a program requirement, we enter the pre-disciplinary and disciplinary process. I cannot underscore enough the need to be responsive to the program administrator. Approved vendors and designees have a duty to be responsive to our inquiries. Failure to respond to the program administrator's requests or inquiries within specified deadlines may result in a finding of a violation of program requirements regarding responsiveness. The pre-disciplinary process begins with a notice of potential violation. This will be in writing and will outline the program requirement at issue, how and why the program administrator believes the entity violated that requirement, and will provide a deadline to acknowledge receipt of the notice of potential violation and a deadline to substantively respond to that notice of potential violation. After the entity responds, if there is a need for additional information, we will reach out and give the entity an opportunity to provide that additional information. If the program administrator ultimately confirms that a program violation indeed occurred, we may take one of a few steps. First, we may issue a warning letter detailing the violation. We may require the entity take certain steps to correct that violation. And for more serious or systemic violations, we may engage in a collaborative process to put the entity on a compliance plan, whereby the entity will have to demonstrate compliance over a longer period of time or risk suspension or expulsion from the program. These steps may be appealed to the IPA prior to enforcement. Finally, the program administrator may pursue disciplinary action against an entity for repeated or serious violations of program requirements. Suspensions will be communicated in letters and are usually for 3 months in duration. It's important to note that reinstatement is not automatic. The letter that we send with a suspension will detail the steps that the entity must take to apply for reinstatement.